Thank you, Heather. Thank you for those introductions. My name is David Damon. I'm a compliance analyst here at Corporate Synergies. Got a very talented panel today. And so I wanted to ask Tom if he would like to give us a little bit more into his background and, his background in ERISA litigation and all of the experience he brings to the table.
Sure. Thanks so much for having me. My day-to-day right now is I split my time between being an ERISA compliance attorney and an ERISA litigation attorney. But my claim to fame, if you look me up on LinkedIn, is I once worked for a guy named Jerry Schlichter who mechanized the courts against 401k fiduciaries and sued everybody, every defense contractor there is on the planet. And I spent 5 years there. Really good, really good place to learn about ERISA and learn how this stuff actually works when things go wrong. And I take that knowledge every day and try to keep my clients out of trouble. So it's the healthcare space seems like deja vu all over again, because I was sort of there at the beginning of when he started those cases all those years ago. And so now it very much feels like deja vu again with the healthcare space.
That's awesome. And yeah, we'll get into some of those cases, including we've got a big one, the claim to fame right now. So Johnson & Johnson is the center of litigation. And this time it's not about the drugs they're manufacturing, but rather the ones that are offered through their prescription drug plans. So I want to start it off. I want Dan, if you wouldn't mind taking us through kind of the details of this case and maybe some of the things that makes this unique.
Definitely. Thanks, David. So the complaint that we're talking about today, which you can download from our e-alert, it's hyperlinked in there. It's a class action complaint. It's the class action complaint of Lewandowski versus Johnson & Johnson. It's filed in Federal District Court in New Jersey. And just as some background, right, on Johnson & Johnson, right? I think they're famous for manufacturing drugs, like you mentioned, David, right? But this is kind of unique because, right, this lawsuit is about the drugs they're offering on their health plan. The company employs over 100,000 people worldwide. Virtually all of the expenses that are for their self-insured health plan are paid out of a VIBA 501c9 VIBA trust. And according to the complaint, based on the most recent reporting, participants made approximately a little over $148 million of contributions into the VIBA trust to pay for this plan. And the plan uses a PBM to manage its prescription drug costs. I'm sure probably most of you on the call are familiar with what a PBM is, and essentially they're an entity that negotiates drug prices really between the manufacturers, the pharmacies, and the employer clients, plan sponsors. And in this complaint that was made by Miss Ann Lewandowski, who is a healthcare policy and advocacy director for Johnson & Johnson. She is also a plan participant. And on behalf of herself and other similarly situated plan participants, she alleges that the PBM essentially went unmonitored by J&J and its plan fiduciaries and significantly overcharged plan participants, and beneficiaries for drugs. And as an example of that, I think probably the most famous example from the complaint itself is there was a 90 pill prescription for the generic drug teriflunomide. I'm sorry if I'm mispronouncing that, but it's used to treat multiple sclerosis.
You did better than I would have.
Thanks. So it would cost on this plan, if the allegations in this complaint are true, right? If we're to assume that everything here is what actually happened, they charged $10,239 for a 90 pill supply, which you could have gotten at cost plus drugs for $28.40, or $40 at Wegmans. So really it looks like excessive fees here, right? So they're charging that to their plan and beneficiaries. It's a price that is 250 times higher than the price available to an individual who walks to a pharmacy and pays out of pocket. And then the complaint further alleges that this plan mismanagement, and in particular of its prescription drug program, violates ERISA, specifically that the plan fiduciaries failed to meet their duty of prudence under ERISA, which we'll be talking about a little bit more. But generally, it's a duty that plan fiduciaries act with care, skill, prudence, and diligence under the circumstances that would, then prevailing, that a prudent person acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character and with like aims. That's the language there from ERISA. But generally speaking, right, what you're required to do as a plan fiduciary is to make a diligent effort to compare alternative service providers in the marketplace, seek the lowest level of cost for the services to be provided, and continuously monitor plan expenses to ensure that they're reasonable under the circumstances. So all of these things, just to provide even more context to this case and kind of what makes this such a, I guess you might say, a seismic change, or really kind of a big a game changer in our field of for ERISA attorneys like us, like me and Tom, right? Is that right before this, or just several years earlier, the Consolidated Appropriations Act of 2021 was signed into law, which, among other things, extended fiduciary responsibility to plan sponsors and their fiduciaries for health and welfare, plan sponsors of health and welfare plans, right? So in the past, over the past decade, probably a little bit over a decade, we've had similar rules to this in the retirement plan world. So, right, so for your 401k, your pension plan, right, your defined benefit pension plan, or your, any retirement plan, right, you had a fiduciary requirement here to make sure that service providers are only charging reasonable compensation, that they're not overcharging, things like that. And for service providers like PBMs, as well as brokers and consultants like ourselves, right, you have to make sure that that's a reasonable price. So this is a big deal, right? Now this responsibility goes to the health and welfare plan sponsors, our clients, the employers, right? They're sponsoring these plans. It requires them to designate this responsible plan fiduciary to make sure that the service providers aren't overcharging. We don't really need to kind of we've talked about this a lot in other webinars and briefings in the past. So we don't need to kind of reinvent the whole wheel in CAA, but I think what's significant here is that for health plan sponsors, currently, right, most of them don't have fiduciary committees in place, right? A lot of them don't have fiduciary compliance procedures. They don't have fee benchmarking, right? They don't have these kinds of protocols and procedures in place to monitor the compensation of their service providers and their PBMs, things like that. And so this is really, and we've been talking for several years now, since the CAA went into law, about the importance of doing this on the health and welfare plan side to our, with our clients. But it's one of those things where we never really saw a case again. We never saw a lawsuit against an employer and plan sponsor that didn't get this right or didn't do what they were supposed to do. So there really wasn't anything to kind of point to and say, hey, look, like here's an example of where it didn't happen right. And that, now, granted, it's just a complaint at this point, but assuming that these allegations are true, this is a really big deal, right? Because it's really the first case example we see in a complaint of a class action lawsuit brought against the plan and its plan fiduciaries and the employer, and not just a direct lawsuit against the PBM directly, like the employer suing the PBM directly or the plan participant suing the PBM directly, which is much more common. So big seismic change here in the ERISA world.
Yeah, thank you for providing the background there. And so, as Dan said, right, it's still just a complaint. So, Tom, can you tell us maybe a little bit how this might move forward? What the next steps might be in this, and how seriously should we be taking this complaint? What's going on here?
Yeah, it's certainly seismic, right? There's a lot of there's been periodic health plan litigation here and there, sometimes about denied claims, sometimes about mental health parity. You see sort of disparate cases filed in disparate situations, and I think the motivator for a lot of those lawsuits are someone feels they're hurt, right? So let's say take mental health for a second, right? You're not getting mental health covered in some type of facility or so on, and so it's driven by the participant, it's driven by the employees utilizing the healthcare. I don't think that's the case with this one. I think what makes this so seismic from my litigator's perspective is this is being driven by the plaintiff's lawyers, right? The plaintiff's lawyers are going out and they're advertising for people to bring these lawsuits, class representatives. My former employer is doing it. If you go on his LinkedIn or his law firm's LinkedIn page and you know where to look to click on advertisements, you can see that he's been running ads for a long time looking for people. And then that is just that sort of plaintiff lawyer mechanized driven approach has not, since 2006, when the first 401k excessive fee lawsuit was filed in that regard, right? There had been a couple other excessive fee cases before that and so on, but nothing like what he did, right? And so then now you're starting to see that he's advertising, others are advertising. To me, that's the seismic shift, is that the plaintiffs' lawyers are now utilizing this from an entrepreneurial sort of viewpoint, right? We can mine cases and mine plans and turn this into a profit center for our law firms. So yeah, and what's interesting is that the plaintiffs' lawyers here who filed are not known in our world. These are not ERISA lawyers. I have access to certain tools. I looked up to see who these folks are, whether they had filed any other ERISA cases in their careers. These are not ERISA lawyers. They're smart. They have good credentials. I think they're both either Harvard Law or Yale Law or something. They had really esteemed clerkships. I think one of them clerked for a Supreme Court, maybe both of them clerked for a Supreme Court justices. So, these are smart people bringing this lawsuit, but they're not a known quantity in the ERISA litigation world. So I think that's really interesting. But one thing that has occurred since the complaint was filed, and Dan, do you remember the date of it? Is it
It's February, I think it was February 5th of
okay,
this
February
year.
5th, right? So sometime between February 5th and late March, a law firm that is well known in the ERISA world, the law firm of Cohen Milstein, must have had some conversation with these folks, the original plaintiffs' lawyers who brought the case. And then a big press release went out on Cohen Milstein's website saying, hey, we're now involved in this. So, and look, if I were them and I was willing to give up some fees to get some extra help, that's probably a sound, prudent decision, no pun intended, right? From an entrepreneurial, risk man. I mean, ERISA cases are really, really, really expensive to litigate. They cost millions of dollars between e-discovery costs and expert costs. And so you hope that ends up being a barrier, right, to all these firms just coming in and suing every healthcare plan they can, like it's happening. It seems to be happening on the retirement side, but these two firms are teaming up, and so what's next, right? What's happening? What's the current update? So this Cohen Milstein firm is now involved. Johnson & Johnson responded to the complaint. You typically have a certain amount of time to respond. You either answer, which means we're going to go now engage in discovery and so on and so forth, or you file something with the court called the motion to dismiss. And basically what that says is, even if everything they say in that document is true, from soup to nuts, front page to last page, everything is true, we're still not liable under the law because of X, X reasons, Y reasons, Z reasons. And so that is what Johnson & Johnson did on April 19th. So just a couple of weeks ago, they filed their motion to dismiss, and they're saying to the court, federal judge, so by the way, this is ERISA. It's claiming a jury trial, but I doubt that's going to happen, right? I know there's been a few minority courts that have allowed jury trials, but essentially, if it follows 50 years of ERISA jurisprudence, this will be right in front of a single judge. The judge decides everything. So now they're arguing to the judge, hey, look, just fine. We know you have to accept what they say is true, but by the way, some of it isn't, because they threw in some facts there against the rules anyway, to kind of argue some stuff about pharmaceutical, about the limits and the per employee limits on what you would cost for a single prescription drug, undermining some of the sexy claims. Like, Dan, that stuff you were talking about before with the 10,000, they took screenshots of the website, put it right in the complaint, right? They were really getting, and I believe even there, they said, like, Judge, this is not a typo. Really not a typo.
Yeah, they wrote, this is not a typo. I've never seen that.
Yeah. And if I recall correctly, the lead drug they picked up on too was like one for like some like cancer or like kids being sick, or I can't remember what it was, but it was like, oh yeah, we're pulling heartstrings right from page 3, like we're just going for it right in, they knew what they were doing and they were going for it. But there's some stuff in the motion to dismiss that suggests some of those facts are wrong, but unfortunately you can't get a lot of that in at this stage. That's for later, right? So judges aren't allowed to weigh facts at this stage, but some do anyway. So, you know, they're pushing the limits. I'd do the same thing if I were these lawyers representing Johnson and Johnson. So, but their primary argument is picking up on a Supreme Court case from a few years back called Thole versus U.S. Bank, and it gets into some really nerdy legal concepts. We're not going to try to kill you here with that, but it essentially it boils down to this idea: if you get your claims paid and you get your prescription drugs and no one denied you a drug and you're paying the prices that were outlined in your plan, what's your harm? Maybe the plan was harmed. Maybe the plan ended up paying too much, right? Because in the actual complaint, it shows that of that $10,000, the plan paid 8 or 9,000. The participant was responsible for maybe 1,000 or something. But any harm goes to the VIBA, it goes to the trust. And
Yeah.
did you not get a medical claim paid? Like, did you go get a colonoscopy and the VIBA ran out of money? Like, that would be an issue, right? And they said the same thing about pension plans in that Thole case, which was, do you really care whether they allegedly mismanaged the plan or not? Because your pension payments didn't stop. You kept getting your $2,000 a month. So what is your harm that you get? And so there's this whole sort of gatekeeper function under Article 3 of the US Constitution, all this, that you have to have an injury. And so this is what I expected to come out of an employer like Johnson & Johnson, right? This is exactly what you would have expected. There's been some other litigation that have been successful. There was a case against MetLife, I think also in New Jersey, the Knutson case, however you pronounce that. We probably should have agreed on how to pronounce these words before, right? Between that drug and everything
I
else.
think you're good on that one. Yeah, I don't know how to pronounce that one either. So.
Yeah, Knutson. I don't know. The K
Knudsen?
is silent. I don't know.
Yeah.
But Knutson, and then there was another case out in California that went up to the Ninth Circuit. That was successful. Johnson & Johnson are citing all these cases. So they're leading with this idea and this concept of no harm, no injury. You don't get to redress, you don't get your day in court. It's interesting, right? It's an interesting approach and different than if other people were bringing the case. But so what do I think is going to happen next, right? My guess is, from my years of doing this, is the plaintiff's lawyers will use that motion to dismiss as a free look of basically what they got wrong in their complaint. And then every case that's filed, you have something, you have the ability to amend as of right, meaning they don't have to go ask the court for permission. They can just amend their complaint and file a new complaint. And then after that, you have to get permission from the court, but the court almost always grants it unless you really screwed up and you're totally abusive and you're on your like 17th amended complaint or something like that, or you waited 4 years to do it. There's things like that. So I expect that what's going to happen is Lewandowski and the plaintiff's lawyers will file an amended complaint, doing their best to plead. It's called pleading around the issues that Johnson & Johnson are raising, with the goal to just survive this stage, to get into discovery, and then get into Johnson & Johnson's files, right? Because right now, these plaintiffs' lawyers don't have access to service agreements. They don't have access to the negotiations with the PBMs. They don't have internal emails. Plaintiffs generally are not entitled to that information. Now, the Department of Labor gets that when they get upset with your plans, right? They have subpoena power, civil authority. They can just come in, they get all that. But plaintiffs, individuals, plaintiffs' lawyers, they don't. So they are praying to get past this motion to dismiss stage to get into discovery. And that's when the millions start, just millions of dollars in e-discovery, millions of dollars in expert costs. And so they will amend. Johnson & Johnson will then try to file, their motion to dismiss again. They'll do as much as they can, the second time around. And so while it's, fascinating and earth-shattering and all of that, it's like there's going to be a second pilot episode of the whole thing. It's like a TV series, right? We have the pilot episode, but then they're going to get a chance to do a new pilot, and then we'll see whether the series gets picked up.
That's great. So thank you for that, Tom. I just wanted to ask, what happens if, and I think we have a similar question basically there, but it was alleged in the complaint, right? The harm that happened here was not just did it raise costs for premiums and the costs of drugs, but also that it also affected their wages, right? It's very early on in the complaint. I think it's like on the second page or something.
Yeah.
It's just this very broadly stated kind of harm. So what happens if they find, let's just say the judge finds that Miss Lewandowski didn't have any harm? I mean, wouldn't there still be harm to the plan and the other participants? And but because I believe she was on leave at the time and she
Mhm.
filed the suit. So it's, it's not entirely clear how much involvement she had in the plan, but obviously this had an impact on other plan participants in the plan itself. So maybe can you speak a
Yeah.
little bit to what happens if they're able to get rid of Miss Lewandowski, but or something like that because there's no harm to her?
Well,
Does the case then still continue? I guess is really the question.
well, I mean, Johnson & Johnson's not going to sue itself, right? I doubt the Secretary of
Yeah.
Labor is going to get into this, right? Because the DOL and EBSA, they've got enough on their plates, right? So they've done a little bit here and there, but they're not interested in a broad, at least that I'm familiar with. I haven't heard, right? I have a few former DOL colleagues that work with us here at our firm, and I've not heard anything like that at the DOL. But if they can knock her out and say, look, you have no injury, and then then it's not going to move forward, right? This thing will be dead if they can knock her and everybody else like her out. And everybody else like her is everybody else in the plan, right? Because if what they're alleging is true, that every participant only pays $125 max on a prescription drug, or even then, or even if they got what the plan promised them and never had any medical claims denied, there's no specific harm. And that's what the Thole decision is about. Like, there may be harm to the Viva Trust, but it's really not your place to enforce. And your stuff about the wages, the legal phrase is going to be speculative. So when it comes time to when they argue that the Johnson & Johnson brief is going to say, look, that kind of injury is speculative, you can't prove it. Where's the email from your HR manager saying, I'm sorry, we couldn't raise wages this year because healthcare costs went up? Now, if that actually does, if there is an email like that, that's, to all our HR friends, like, please don't write emails like that.
Yeah,
I know
don't
people
write that
talk like
email.
that sometimes at the water cooler, right?
Right.
Bosses get frustrated when they see their health
Yep.
plans go up 10, 15, 20%, and on. But please don't put in writing things like, yeah, I can't raise wages because our healthcare costs went up. So I think Johnson Johnson will say that's speculative. It's essentially throwing stuff up, like spaghetti up against the cabinet. And, if this plays out like the other cases, then the courts, there's a really good shot the courts will say, no, you weren't harmed, there's no injury, there's no standing, and make the case go away. But it only takes one judge. It only takes one judge to decide that there's something there, something they don't like, and they say, you know what? Let's go to discovery and see what happens, and I'll decide later. Only takes one.
That's super interesting. And it's one thing that, Dan, I've heard you say it 100 times, is like the one thing that's super novel about this case that's kind of an outlier from everything else is the complaint lists like the individual fiduciaries of the plan, the people who comprise the committee. So
Right.
can you tell us a little, like, for all the people who might have an interaction going forward with their fiduciary committees and all of these HR managers, can you tell us like what's so interesting, what's so novel about that?
Yeah, I mean, I think the immediate thing here, right, of significance is um it's novel because in most cases like this, um, right, the employer or the plans just sues the PBM directly, right? They say, look, you overcharged us. We just want, we want that back, suing you directly. Like there's some cases like Kraft Heinz versus Aetna and things like that, where they just sue the TPA directly for a TPA that allegedly mismanaged things. So, so that's typically what's happened thus far. And what makes this really unique is that they they didn't even name the PBM, which I believe was Express Scripts. They didn't even name the PBM in the complaint. So they're just really doing directly for the company and the plan's fiduciaries. The fiduciary committee is named itself. So that's what makes it really unique. Now, just as an update, there was an agreement between the parties to take the individually named fiduciaries out of the complaint, which is relatively. It's my understanding that that's really. And correct me if I'm wrong, Tom, because I don't do litigation every day, but it's my understanding that that's relatively common, just because. Right. In most plan documents, the employer agrees to indemnify the plan fiduciaries in these types of situations, and plaintiffs have agreed to that. So, but aside from that sort of procedural thing that happened in this case, and that typically happens, it's unique because they're not just suing the PBM directly, which is what we've seen in the past in a lot of the health and welfare plan cases about fees and things like that. Tom, anything you want to add to that as far as
Yeah,
your, yeah.
people people tend to forget that ERISA liability is personal. And sometimes that means personal to the corporation when the corporation is the named fiduciary in the document or something like that. But we as individuals, a corporation doesn't have arms and legs, right? So someone has to, it doesn't have a brain. Somebody has to make discretionary choices, and that's the individuals that operate on behalf of the companies. And so it is absolutely a tactic of the plaintiff's lawyers to sue. This doesn't happen all the time,
Mhm.
but I used to do it in my former life, and then you would play cat and mouse games, like the lawyers for the employers wouldn't accept service, meaning you'd have to go hire a process server, like things you see on television, like
Right.
hopping out of bushes and stuff like. And then you wouldn't serve the person, you'd serve the person's spouse and their kids with groceries in the minivan. Seriously, and the kids would be like crying, like, "Mom, what's going on? Why are you getting arrested?" I mean, this is why I don't do plaintiffs. I mean, is one of the reasons I left plaintiffs work, because
Right.
that exact story, right? We literally served this person, this executive from some company that was sitting on the board of a major financial services company, and his children started crying in a minivan. It's like, so it's a total leverage play. It's a total leverage. They're naming these
Yep.
people just to get their attention and pop them in the face, right? And
Yeah.
and get them to react and say,
Yep.
this isn't,
Yep.
we're not joking around. It's a total litigation fight tactic, intimidation tactic. That's my take on it.
Yeah, no, that's great. And I think one of the other things too is we often talk about, you know, at least here on the compliance side when we're advising clients on what to do, what not to do, right? Um, you know, even if let's say you have the best plan doc, and you do everything right by the right standard operating procedures for what you need to do, and you agree to indemnify your plan fiduciaries and everything else as an organization, you never want to be in that situation, right? So like you never want to have your people who are plan fiduciaries have their name in a lawsuit. They don't want it. The company doesn't want it. And so one of the, I guess you might say, reasons, I guess you to get into compliance, right, with these things and to really listen and to, make sure you're doing your fiduciary duties correctly is to make sure that you don't have any of your individual fiduciaries named in a
Yes.
complaint. I think is kind
Yes.
of the takeaway, right?
People look at insurance and indemnity and think it's a catch-all. It's really just about damages. It's not about liability.
Yep.
Liability attaches. It's nice that somebody else is paying the bill, but
Yep.
liability is personal. My client base, the one like the publicly traded companies with prominent directors who you don't want getting sued. And the other one that I always am super sensitive in this area too are like local prominent nonprofits, where the board is basically a fundraising board. And yes, there's some governance, but essentially your board are prominent members of your community, whether you're an art museum or a symphony or a theater organization, things like that. You want to insulate those people because you don't want your donors or your famous board of directors getting sued on this stuff. So yeah, there's a whole lot of, you referenced, Dan, the compliance. There's a lot of compliance that folks like you and I can put in place to insulate those people, but no one's been doing it on the healthcare side because there hasn't been lawsuits. Retirement
Exactly.
side, yes. Healthcare side, I've not done one of those in 20 years, right? Because no one
Exactly.
was suing under health insurance. So it is a sea change for so many reasons.
Yeah,
Exactly. Yep.
that's super interesting. So one term we've been throwing around a little bit is this concept of prudence as it pertains to fiduciary. So Tom, can you tell us a little more about, kind of what that standard looks like?
Yeah, it's funny that most of the standards for fiduciary responsibility have been developed on the retirement side. Because if you're a student of ERISA and you go back to, pre-ERISA times, the famous case that people say, what's going on with ERISA? Why do we have the ERISA law in 1974? They cite Studebaker, the car company. Studebaker was not about fiduciary. Studebaker was about vesting standards and funding standards. I worked there 29 years and 6 months. I don't get my last 6 months. I lose my whole pension. That's vesting. Or I did make my 30 years and you only put $10 in the plan. There's no money to pay us. That's funding. That was Studebaker. The fiduciary side of ERISA and why you have all those rules were because the Teamsters were stealing from their health plans and using it for strike funds or buying pink Cadillacs or casinos in Vegas or Lord knows what the Teamsters were doing in the 60s. And there's lots of movies. You can figure it out, right? So it's ironic to me that we have all these fiduciary duties because of the health plans. And then there hasn't been much, and it's been most on the retirement side. So what does prudence look like on the retirement side? Well, there's sort of two forms. You have to have good process, so procedural prudence, and then substantive prudence, you got to make good decisions. And so on the retirement side, what does prudence mean in real life? It means we have our quarterly meetings or our meetings twice a year, once a year, depending on, what's necessary with the plan. And we have reports that we look at, and we capture the way that we select and monitor and terminate investments on our investment policy statements, right? And maybe some of your plans out there, for those listening, you have a fee policy statement. That's sort of a new thing, a newish thing, new best practice that people are doing. And that's just another way of writing down what our procedural prudence is. So again, we have committees. Dan, your reverence, we have committees. We don't just leave the buying of the retirement plan services willy-nilly, right? And not that that's being done on the health side, but certainly not in a sort of organized fashion with meeting minutes being kept and fiduciary training around the decision making and so on. So to me, that is the retirement world, and that's the challenge for the healthcare plan fiduciaries. That wait, we've never really had to do this. The buying experience is totally different, right? Because the healthcare market is just very different than the retirement market, where there could be hundreds of providers, where on the healthcare side, there may be less than, the number of fingers I have right here, right? So it's been a different experience. And now for all those employer plan sponsors out there, it's taking those prudence lessons from the retirement side and applying them as appropriate to the healthcare side. And that's really just in its infancy. And I've been involved in that for about the last 2 years. I know, Dan, you've been, getting involved in that as it's, since CAA, and it's been, but prior to that, did any client ever call you asking to put in place a committee on this stuff? I mean,
Exactly. No,
not
that's what
private
we
employers,
yeah, that's a great
not private
question. Yeah,
employers.
100%. I mean, I think what we've talked about in past episodes, you might say, or past compliance briefings and webinars we've done here at Corporate Synergies, we've talked a lot about what we joke around about is the Uncle Larry problem, right? Is essentially that your Uncle Larry is getting the brokerage business, and he's getting he's getting all this money of direct, and indirect, in some cases, compensation, just for being the golf buddy of the CEO, or the family member of the CEO, or something like that, right?
Always the brother-in-law. It's always the brother-in-law.
Yeah, it's the brother-in-law, it's the Uncle Larry, it's one of those people who knows everybody, who knows the CEO really well, and that person ends up getting a lot of business. And one of the things that really changed in the health insurance world, and I think for the better, right, is that when the CAA came along, it really made sure that those Uncle Larry brokers, and no offense to Uncle Larry, and I'm sure there's great brokers named Larry, but so no offense to the choice of the name Larry, but now because of the CAA, right, there's all these other additional things you need to show. You really need to show what you're doing for how much you're getting paid, right? You have to show what if you can't say the exact amount of the compensation, you have to give the formula, right? The PEPM or whatever it is for how you're getting paid for the services you're providing. And that really did not exist. I mean, it did not, there was a lack of that in the health and welfare space, really prior to the CAA.
Huge sea change.
Yep.
And it's being fought. There's providers out there, and the scope of it, and there's been some congressional hearings this past year, and there are people, the DOL has certainly taken an expansive viewpoint of how to interpret that language, but yet people are ignoring them, right? And so yeah, no, absolute sea change, and as they say, sunlight is a heck of a disinfectant. So for those who maybe have been making money and not disclosing it, or making money and frankly not earning it, right? Because I personally don't have problems with a broker or a retirement plan advisor or whoever making money. Like they provide a valuable service, right? And that's fine. Let's get the sunlight on it. But those that don't do anything but push a couple pieces of paper and make a bunch of money, that's not going to fly. And now with this being applied, they're going to have to justify why they're making that money and show that there's value. Value, no problem, right? But no value, I see that as a problem.
100%. And so if you think about this concept of prudence, right, and you tie it back to the Johnson & Johnson case itself. So what are some of the takeaways from kind of at least the complaint that they might have done that might have lacked prudence?
Yeah, I mean, I think the kind of immediate case takeaways here, and obviously, look, it's just a complaint still, like we've said before, but I think really, if these allegations are true, right, what we're seeing here is really the fiduciaries, those who are responsible for making sure that the plan was only, wasn't overcharging, was only, that the service providers were only receiving reasonable compensation. Somebody was essentially asleep at the wheel, or was not really, was negligent, or didn't really fully see everything that was going on. And so in many ways, the way to look at this is really, this case kind of comes down to, well, how diligent was that fiduciary committee, right? How did they really select? How did they select that PBM that charged the over $10,000 for the $28 drug, right? How did they get there, and what kinds of policies and procedures and processes were in place to allow them to monitor that PBM and their compensation and what they were doing? Were they, were these plan fiduciaries really just figureheads, or named fiduciaries in the plan document, right? Because you have to have a, under ERISA, there's sometimes you see just a named person or a named, entity or committee, but there's really no substance there, right? So I think in many ways, I think one of the big takeaways here is that you really need to actually take what those roles and responsibilities that may be listed in the plan document, or maybe on the name of your committee as a fiduciary committee, and you have to really put those things into practice, right? You have to create an operational reality behind what it says in your plan document. And so I think, as to be a little bit more specific here, right, fiduciaries need to put a formal process together, right, for reviewing service provider compensation. So like at the outset, for example, designating roles and responsibilities for the plan fiduciary and the fiduciary committee, including, initially setting up the committee, right? Setting up a fiduciary committee, creating a charter, creating a schedule of meetings, ensuring that those meetings actually happen, and that minutes are taken at, that there's a writing that memorializes what happened at those meetings. And keeping things in writing is a big, important piece for reducing fiduciary liability. Then, of course, once this fiduciary committee is meeting more regularly, right, having a process for selecting and reviewing the compensation and services provided of each service provider to the plan. Also, perhaps establishing a formal bidding process, like an RFP process, and establishing other fee and performance metrics like benchmarking. So it's not enough to just really simply just have that named fiduciary in your plan document, or having a process or policy, written in a policy document somewhere, or a plan document. You really have to actually do the work, right? You have to show up for that committee meeting. You have to put things in writing. You want to make sure that you're actually reviewing those benchmarking results and so on, and really putting those things into practice, I think is kind of the takeaway here, right? So, and that's what's going to really help you as an organization, right? If you're, an HR manager, or benefits manager, or someone like that, or another person who has a role in your organization with regard to overseeing the benefits, those are the things that are going to keep your name off that next complaint.
Right.
So,
and let me just take a second and explain how that plays out in a court, right? So I was just in front of a federal judge 2 weeks ago, arguing a motion to dismiss out in San Francisco. Wonderfully thoughtful judge. Sent us a list of questions ahead of time. She clearly had gone through all the briefing, had really understood the issues, and wanted to zero in and focus in on, the questions that she was struggling with from the motions. But even for a judge who doesn't do that, keep in mind that these judges are generalists. And that's what's lost on a lot of folks who aren't in courtrooms all the time presenting to these judges. They think judges are experts. They become experts by the time the case is over. But generally speaking, I think we were in front of her on a Tuesday, and that was civil docket day. And I think we were the only case. But sometimes I go in front of a judge on a motion, and they have the U.S. attorney arguing white collar something, fraud, crime that day, and there was some god awful other case the day before. They have 300 or 400 cases on their docket anytime, and 4 of them are ERISA, right? And 396 of them are every other myriad, case under the sun. And so why, Tom, why am I saying that, right? Because if the best these plaintiffs' lawyers can do is present a non-feasant sleep at the switch complaint, like you just didn't have enough diligence, judges, my experience, judges just, that doesn't resonate with them as strong as, oh, you were malfeasant, you were self-dealing, right? That's why the self-dealing ERISA retirement cases are so much stronger and have so much bigger damages or settlements, because it's like, oh, you're a jerk, you were stealing. Well, that's just like my white collar crime guy yesterday, right? I get that. I get that you're not supposed to be stealing from your employees. However, in the retirement side as the corollary, when you're arguing to a judge, well, judge, you were supposed to do an RFP every 2 years instead of every 4, and you were supposed to benchmark every year instead of every 3, you just see a pile of cases. And in my interpretation of them are, these judges say, you know what, this is hard. I resonate with the fiduciary who struggles with this stuff because this stuff is hard. And as long as it's not window dressing, because that would be too far. It's not just as long as you have any process, you're going to get out in court. But as long as you have a decent fiduciary process, even if it didn't result in perfect decision making, but you were trying and generally acting in the best interest of plan participants, there is a pile of case law these plaintiffs' lawyers on the health side are going to run right into. It's like a concrete wall in a sports car, right? Where these judges are like, no, I think this process, was it perfect? No. Could you have maybe made a decision 6 months quicker? Maybe, right? But you met regularly, you had a good committee, you did all these things. And Dan, I'm sure you've been talking about these cases, on these forever. I think especially with healthcare, when it starts to get into some of the more convoluted, complex ways that these things happen, coding and how PBMs talk, and the judge's eyes, they're just gonna say, this is so impossibly difficult to understand. I sympathize with the ERISA fiduciary that's being sued. And so as long as you have, so to your point, Dan, when you put these things in place, it's going to be hugely insulating to the extent to any of these plan sponsors getting sued, just showing that they had a decently prudent process in place. I think in the long run, that's going to be good enough.
I agree 100%. Yeah. You gotta start by doing something. And yeah, so maybe you don't do like benchmarking every year, or you don't do every single little thing that you might need to do. But that's such a valid point. It's such an important point that you just made. And I think it goes to also another thing you can do to insulate, like I mentioned briefly, but I think it's really so important, especially if you're not able to meet and do all of, if you're not, doing 110% of every little tiny thing that you should maybe be doing as a fiduciary in the best practices world, ideal world. It's always the most important thing to do is to keep things in writing, I would say, at least
Yes.
from my experience,
Yes.
defending, in private practice and in the real world out there, you really want to keep things in writing, because at least it shows that you met, right? It shows that you met to have that meeting. It shows that this is important to you, that you were acting in the best interest of the plan participants. And so that's probably one of the best things as well, setting up that committee or setting up a meeting, and then kind of documenting that it happened, keeping the minutes in a file, and keeping other things in writing as to, for example, why you selected that PBM, right?
That's right.
That's going to take so much liability away.
Yes.
Yeah.
You might have to fight, which is why we have ERISA fiduciary insurance.
Yep.
Right. And I don't have it. I wish I had fiduciary insurance to sell. I'd be rich. Right. But it's the insurance is what pays the legal bills in order to show what good process you had. So I can't, if the one takeaway from any of this is, for those folks listening, please call up your broker and make sure your health plan is covered under the same policy as your retirement plan. And if you don't have a policy at all, well, then get one.
For fiduciary liability insurance.
Yes, fiduciary liability, specifically ERISA fiduciary liability.
Yeah, I mean, so that's a lot of the legal standard and how to keep us, in compliance, make sure we're doing a good job. But can we maybe touch on a little bit, practically for these people who are trying to, run a health plan, facilitate the benefits? How does, benchmarking and taking this prudent process, how does that impact the plan positively? What's the positives, not just the stay out of court?
Well, I think saving money, I think, is probably the biggest one, right? I think, right. I mean, I'll let Tom, you can weigh in after me on this, but I think that, one of the big things that you can do to kind of to get there is to have a great ERISA attorney or other a contract attorney even really who knows something about the industry, to look at those service provider agreements, and see where there's areas, make sure that they're doing what they say that they're going to be doing for the money. And I think it's not enough to simply find the cheapest provider, right? It's simply not enough to say, okay, well, we know they're charging reasonable compensation because it's so much less than the other guys, right? That's not enough, right? You have to, like the prudent person standard says, right? You have to look at the kind of you have to look at this under the circumstances, right? For this industry, for this geography that you're in, right? This organization where it is, right? And then have your contracts reviewed by an attorney. So Tom, you just did the sales pitch for us as an insurance broker to buy your fiduciary liability insurance. So I guess our sales
there
pitch
you
for you
go.
guys is to have your TPA agreements or other service provider agreements reviewed by an attorney. I think that's a really
Yeah.
important piece.
I do that. I do that all the time. The only thing I have to add to what you said is I went to a healthcare innovation conference last October in Washington, D.C. And the people, there's not a lot of infrastructure out there right now for plan sponsors who want this, right? There's certain people, there are ERISA attorneys, there's organizations like yours who will help and assist. But generally speaking, the health side of prudent process is not as well developed as the retirement side. And to the extent that it exists, I met some of the folks out there doing that work. And this one individual, I mean, look, it's important work, but the entirety of their process was getting a drug report and comparing it to the formulary list, and then pointing out to the PBM that they were like paying for drugs that weren't on the formulary list, and getting the money back, right? And then basically just cleaning up, doing a simple claims process. And oh, by the way, this consultant would take 30% of the savings as a bounty fee. Bounty hunt, I guess a bounty hunter fee, right? Essentially, it's like that. So there is not I don't think there's certainly on the self-insured side, there is not a healthcare plan in America that wouldn't benefit from more process. Just considering the way that the marketplace exists and how there has generally been a lack of transparency, some could argue by design, right? And it's certainly not on the heads of the employers, right? That's the marketplace they have to buy into. There's not a healthcare plan in America that wouldn't benefit from some type of process being applied in different areas, whether it be pharmaceuticals, medical claims, or wherever, right? To try to find savings. It's just the nature of the beast of the product.
100%. I think that's really one of the big things that's going to be coming out of this is that of this litigation that, regardless of which way it goes with regard to Johnson & Johnson, right? A lot of plans, once they set up those fiduciary committees or once they start reviewing the service provider agreements, they're going to find a lot of cost savings because it's just going to bring a lot of things to light that they didn't see before. And then they can also, right, with an attorney, negotiate better provisions in those service agreements, right? You can negotiate a service level agreement that might allow you to claw some of that money back if the service provider doesn't do what they're supposed to do, right? So that's, I think, a big thing that comes out of this, like as a practical matter, is the cost savings that comes from transparency, much more so, I think, than a lot of these other provisions of the CAA, like the gag clause attestation form and the prescription drug reporting stuff that's going to publish a report about prescription drug costs and things like that, right? Those other little compliance requirements, I think, don't really give you that much extra transparency, but setting up a fiduciary committee and really, bringing a lot of these things to light is going to be a big takeaway from this. It's going to be a big cost savings for employers and plan sponsors.
Yeah, and there's been a few lawsuits that have been brought not by the employee, well, more than a few, but it's the employer. Like you mentioned earlier, the Kraft Heinz versus Aetna case, right? That if you read that complaint, and we don't have enough time to get into it. And again, with the clause being all of it could be nonsense, right? We just don't know. It's an allegation. It's not a fact.
Yeah, it's true.
But if half of what they allege in that complaint is accurate as to the way claims are being processed, these lawsuits are going to lead to, if I'm, I don't know, pick another major employer in Pittsburgh, right? Like I'm reading that one and I also have the same carrier. I'm picking up the phone to my broker consultant or my carrier rep and saying, are you doing that to me? And so even just the filing of these cases presents facts and information, even in the form of allegations, that some plan sponsors just have absolutely no clue is happening because it's so hard to get behind the curtain. And so I think, again, there's many, many, many layers of transparency here, and the employers can't ignore it anymore. That's the bottom line. That's what I see happening. It was easy to just say, look, this is how business is done. This is the best I can do. I'll just write my $12 million a month check whenever they tell me, the TPA calls me and tells me I have to write the check this month. Those days I think are gone. Do I think we're to the point where, the Schlichters of the world are going to be suing 100 plan sponsors a year? No, I don't think we're there yet. But I think the days of pretending or hoping this isn't a problem. I don't think anyone pretended, but hoping this isn't a problem or having other priorities instead, the myriad thousand responsibilities that our HR professionals and finance professionals and our clients have to deal with, whether it's FMLA or the FTC thing that happened this week. Yeah, apparently non-competes are out, right? That set off a firestorm, right? There's a million regulations our clients have to deal with every day of the week. This is going to start moving its way to the top, whether people like it or not.
Yeah, and to your point, so we've seen this is Johnson Johnson's a pretty big employer. We mentioned was over tens of thousands of employees, and so the question really is, for some of our clients, they might think, wow, they're a bigger fish. Might this end up, working its way down the chain more towards the smaller type of employers? What do you guys see as a trend?
Yeah, I think it will. I mean, I think well, it's important to remember, first of all, that, I think in the initial stages, right? Like right now, right? I think in the initial stages of these things, it probably will be more limited to those larger self-insured plans with,
I agree.
tens of thousands of employees. But under ERISA, right, as it was amended by the CAA, right? All plan fiduciaries, every plan, regardless of whether you're fully insured or self-insured, has to designate a responsible plan fiduciary to monitor the service provider compensation. So it's not limited to just self-insured plans. So I do think it will at some point hit more and more employers and plan sponsors beyond just those really large ones.
Yeah. If it follows the pension, the retirement 401k trend line, the biggest of the big will get hit first because the plaintiff's lawyers want maximum damages. It'll probably be 3 to 5 years for the DOL to trail. They'll watch the lessons of the plaintiff's lawyers and see what kind of success they have in the courts. And then their investigators will start asking questions, right? That's, I think, a 3 to 5 year lag. And then once the litigation gets mature, yeah, then you're going to go down to those employers with 1,000 people or 5,000 people, much smaller, right? But correct me, Dan, you may know these numbers better than I, right? But I think the statistic on the 401k or any kind of tax qualified retirement plan plus IRAs is in any given year, the number is between 15 and $20 trillion or something like that, that the assets held by United States citizens across, from coast to coast, right?
Sounds right.
I believe it's $3 trillion a year in healthcare spending every year.
Yeah.
So you don't have to just go after the $1 billion plans like on the 401k side, right? 3 trillion divided by all those employers out there, that leaves a lot of meat on the bone for plaintiffs' lawyers to come in and make claims. So yes, I think there will be a corollary and a thing, but on the healthcare side, there's just so much more money in play in any given year that you don't have to just go to the Johnson & Johnsons or the Kraft Heinz's or the big defense contractors. You can go down to those smaller mid-sized employers and still get the attention of the plaintiffs' lawyers who are happy to make $2, $3, $4, $5, $8, $10 million in attorney's fees at a clip. That's a good payday for them every day of the week, and they're happy
100%.
to do it.
100% agree with that. Yeah.
Yeah. So, just as we're reaching the end of our time here. So I just wanted to wrap up and ask if there are any sort of, best practice recommendations, a nice little take home for these fine professionals who joined us today.
Well, I think as far as a lot of the things we've kind of already covered, but I think one of the big things, right, is, make sure you're designating a fiduciary to monitor the compensation of your service providers and their fees and what they and if you can, and if it's possible for your organization, you should establish a fiduciary committee and have regularly scheduled meetings And then, of course, like I said before, keep things in writing, right? If you're doing the analysis, right? If you're comparing fees, you're doing benchmarking, if you're doing the work, right? Keep a written record of that work, right? That's going to be really key in order to insulate yourself from liability, lower your exposure. But really, I think those are really some of the big takeaways, right? Don't just have a named fiduciary in your plan document or someone on paper who's the fiduciary, but do that, do the work. You don't have to be perfect at it, like Tom said, right? You don't have to do everything. You don't have to do everything in the first year, but start that process, put a process into place and keep a written record of it. And I think you're going to be in really good shape.
I agree 1,000%. The only thing I'd add is some of the experiences I've had in the last 2 years of working with plan sponsors and providers and consultants supporting plan sponsors is hesitation on the part of the employers, right? Or hesitation on the part of people inside the organizations to start scratching at the surface. So if anyone has ever had the pleasure of rolling out a new piece of software, right? Or, oh, we're going to roll out an intranet at this company, right? You need buy-in from the top all the way down to the bottom of that organization into that process. And everyone has to have a seat at the table and everyone has to be rowing in the same direction. My advice, picking up on what you're talking about, Dan, is the entire organization's leadership has to buy in and everyone has to be cool with potentially finding out that, you know what, we could have done better yesterday, and that's okay. Because some of the hesitation I've seen is that people who are already overworked, HR people, finance people who are already overworked because of the 1,000 things they have to do every day, who wants to voluntarily bring the spotlight onto their job positions and say, you know what, I could have saved you $1 million last year. I'm sorry, board. I'm sorry, CEO, but I couldn't do it because you already had me working 70 hours a week. No one's going to care. Right. So I think if I got an opportunity to speak to a board, right, I would say you need to have open heart, open minds about this process going in and everybody rowing in the same direction and be okay with what you're going to find as part of that process. And don't play the blame game. Just play we're moving forward game, right? Because there's real humans who have interacted with these carriers and the PBMs and contracts, and they're real people with a million things to do. And if we kind of open have an open-minded aspect, we will get so much farther inside the employers. And in the employers that I've seen that don't have that, and it turns into infighting, that doesn't actually get anybody anywhere and still leaves us with the same problem. So I'm sure that's not the answer you were expecting me to say, but it's a little bit of kindness, I guess, maybe grace and kindness. I sound like Mr. Rogers, like right? But a little grace and kindness.
It does go a long way. It really does. In this world that we're in, there's so much blame that could possibly happen, but just coming in with an open mind and being kind about it and just understanding, hey, we're going to make this better going forward. That really does so much. It really does. So it's a great point.
All right. Well, thank you so much, Dan, Tom, for taking the time, and all of you for hopping on here. Heather, we'll throw it back to you.